the Act of Quebec of 1774 gives back to the French Canadians certain rights and benefits that they enjoyed under the French reign and that they had lost following the conquest by the British in 1763. The Act of Quebec repeals the Royal Proclamation and explicitly recognizes that it was not a useful tool to govern French Canadians and the inhabitants of Quebec at the time. One of the things it's going to do is to allow French Canadians to keep their religion, and it will install a system of civil law for them to interact amongst each other. This is the same system that they used back when France was in charge. Beverley McLaughlin, a former Chief Justice of the Supreme Court of Canada, once said that the Act of Quebec was the beginning of legislative bilingualism in Canada. This claim is supported by the fact that the Quebec Act is the first act to be translated in French. The translator, Maître Cugnet, was himself a French Canadian who advocated to adopt the Act of Quebec and bring back civil law to French Canadians, as well as guarantee their freedom of religion. This is why the Quebec Act, although it does not explicitly mention French or provide French as an official language of Canada, is a foundational piece of legislation that will help bring forth Canadian bilingualism. The first act to specifically mention language is the Act of Union in 1840. It provides that English has to be used in official documentation in the province of Canada. 8 years later, following French-Canadian efforts, the section of the act that provided that was finally repealed. This left an opening to use French in official documentation as it was no longer explicitly prohibited. In 1867, at the birth of Confederation, the British North America Act is adopted. It's now known as the Constitution Act of 1867. This act allows for the use of French and English in the federal parliament as well as in the legislature of Quebec. It also provides that English and French must be used to produce official documents emanating from both those chambers. Later, this constitutional protection will be extended to other provinces. Since 1867, in parliamentary affairs, French and English has been used, as much on the federal level as at the provincial level for some provinces. In the 60s, there's a royal commission that's going to recommend that French and English become official languages of Canada. This will happen in 1969 with the adoption of the Official Languages Act. However, they still don't benefit of a constitutional protection, which means that this status can easily be modified. In 1982, the Canadian Charter for Rights and Freedoms is adopted, which constitutionally protects the official status of French and English. This protection will also be extended to New Brunswick, which becomes a constitutionally bilingual province. The Charter also includes substantive linguistic rights, such as the right to instruction in the language of the minority. Linguistic rights protected by the Charter are unalienable. That means they can't be infringed upon by a government, even using the notwithstanding clause, which allows governments in some specific cases to infringe upon specific rights. In other words, linguistic rights protected from the Charter are protected absolutely. Unlike some other rights, they can never be infringed upon. Bilingualism is also protected by the Supreme Court of Canada, which renders decision that protects the rights that are enshrined in the Constitution, as well as give us decisions that interpret the different rights and tell us exactly what they entail. An important decision of the Supreme Court is the Manitoba language rights one. In 1985, the Manitoban government approached the Supreme Court and asked it whether all of its laws were invalid because they had not been translated in French. The answer of the court? Yes. The government was given a delay to translate all of its laws adopted since 1870, its inclusion in Confederation. The Supreme Court's approach to language rights has not been static. It's changed and evolved over time. In its initial decisions, the court had a more narrow interpretation. It will eventually evolve to a more liberal and purposive analysis. Examples of a more narrow approach can be found in the Société des Acadiens and the MacDonald decisions. In the Société des Acadiens decision, it was determined that the right to express oneself in French did not include the right to be understood in that language. That meant the judge did not have to be francophone. Similarly, in the MacDonald decision, it was determined that the Quebec government did not have to issue a speed ticket in English for it to be valid. As long as it was either in French or in English, it was constitutionally permissible. Eventually, the Supreme Court changed its approach. In the Maillet decision, it was decided that when the numbers warrant, the right to education in a minority language does not simply mean the existence of facilities in that language. It allows you the right for management and control of those facilities. Another example of a more generous and purposive approach is the Beaulac decision. In this decision, the Supreme Court decided that the accused in a criminal matter has the right to be tried by an institutionally bilingual court. That means both judge and jury have to be bilingual. In conclusion, legislative bilingualism in Canada has evolved through its laws and through Supreme Court decisions, and will continue to do so through the years.